Hello, my name is Kelly Stoner. I'm a victim advocacy legal specialist with the Tribal Law and Policy Institute. And along with my colleague, Virginia Davis, who's a consultant for the Tribal Law and Policy Institute, we're going to be presenting an overview of VAWA 2022 Special Tribal Criminal Jurisdiction. Next slide. The overview will consist of some points distinguishing VAWA 2013 and VAWA 2022 regarding the tribal jurisdictional provisions. Next, we'll move on to some details about the InterTribal Working Group, also known as the ITWIG. And finally, we'll provide some resources at the end of the slideshow. Next slide. We'll be doing some distinguishing, if you will, between VAWA 2013 and VAWA 22. But first, let's focus on the problem. The problem is Oliphant, the Supreme Court case that was handed down in 1978 that held that tribes had no criminal jurisdiction over non-Indians committing crimes in Indian country. Exacerbating that problem, we have infrequent prosecutions by both federal and state authorities and high rates of violent crimes being committed by non-Indians and tribes having no criminal measures to hold those non-Indian offenders accountable. Next slide. So here's the distinguishing piece between VAWA 2013 and VAWA 22, some of the pieces. VAWA 2013, as you all might know, affirmed inherent tribal authority to exercise criminal jurisdiction over non-Indians committing crimes in Indian country for 3 crimes. And you see those listed on the slide: domestic violence, dating violence, or violations of qualifying protection orders where the violations occurred in Indian country. VAWA 22 built on this framework and added additional categories of conduct that can be prosecuted against non-Indians in tribal court. Both VAWA 2013 and VAWA 2022 amend the Indian Civil Rights Act, and the citation to that act is 25 USC 1304. Next slide. This slide demonstrates some very important dates in this process. You might recall that VAWA 2013 went into effect nationwide after a pilot program on March 7th of 2015. Since then, any tribe that could comply with the statutory requirements could prosecute these crimes with no approval from the United States Department of Justice or the BIA. VAWA 2022 was signed into law March 15th of 2022. Important to note that VAWA 2022's effective date is October 1 of 2022. No approval from the U.S. Department of Justice or the BIA is required for a tribe to begin to exercise VAWA 22 as long as the statutory requirements are met. I just want to note to everyone that this slideshow, this program is being recorded on April the 8th, 2022. So let's talk about what happens, tribal criminal jurisdiction over non-Indians committing crimes in Indian country can tribes prosecute before October 1 of 2022. And those violations, those crimes that were committed before October 1 of 2022 should be prosecuted in accordance with VAWA 2013 and the applicable tribal code. For crimes that occur after October 1, 2022. Those crimes can be prosecuted in compliance with VAWA 2022, as long as the applicable tribal code allows it. Next slide. Virginia, I'm going to turn it over to you.
Great. Thank you so much, Kelly. I'm going to talk in a little bit more detail about VAWA 2013 and VAWA 2022 and how they fit together to create the overall framework for tribal jurisdiction over non-Indians. So as Kelly said, both of these statutes amend the Indian Civil Rights Act, 25 U.S.C. 1304. So if you're looking for the legislative or the statutory text that we're talking about, that's the place to go to find it. And in VAWA 2013, as Kelly said, it recognized a tribe's inherent criminal jurisdiction for 3 crimes: domestic violence, dating violence, criminal violations of a qualifying protection order. And then there were some conditions on those crimes. Specifically, the crime had to occur within the tribe's Indian country. The victim needs to be an Indian, and the defendant, so the non-Indian who committed the crime, needed to have sufficient ties to the community. That's the framework that was set out by VAWA 2013. It also required tribes to provide a list of due process protections for non-Indian defendants that we'll talk about in more detail later in this presentation. Okay, so now quick overview of VAWA 2022 and how it differed. So again, after October 1st, 2022, the law was amended so that it adds recognition of a tribe's inherent criminal jurisdiction in additional categories. Those categories include child violence, sexual violence, stalking, sex trafficking, assaults of tribal justice personnel, obstruction of justice. And then those 3 conditions I talked about on the last slide, they change a little bit too under VAWA 2022. Now, the crime must still occur within the tribe's Indian country. That's unchanged. And the victim must still be an Indian for most of the crimes, but not all. And I'll talk more about that in a couple of slides. And finally, the defendant's ties to the community are no longer a condition of tribal jurisdiction under VAWA 2022. So VAWA 2013, it mattered. The defendant needed to live in the tribe's Indian country, work in the tribe's Indian country, or be in a qualifying relationship. And those are no longer true under VAWA 2022, no longer required. There's also one small change in VAWA 2022 to the due process protections that adds a requirement that tribes must provide notice in writing of certain rights. I'll talk more about that later too. Okay, so I'm going to now zoom in even farther on VAWA 2022 and talk about what those changes look like. So again, as we've said a couple of times, the amendments from VAWA 2022 have an effective date of October 1st. One thing I'd like to say, as Kelly mentioned, we're recording this and giving this presentation in April, and we know with this new law that it will take a while and take a lot of work on the part of a lot of smart, motivated people across Indian country to figure out exactly what this statute means when it's implemented. So we don't have all the answers right now. We are everyone's still digesting the language and figuring out exactly what it means. But in this presentation, we're hoping to share what we know and what the statute looks like. Okay, so a couple of terminology things. Under VAWA 2013, we talked a lot about special domestic violence criminal jurisdiction. That was the name that the statute gave to the tribe's authority to prosecute non-Indians. Under VAWA 2022, that's replaced with special tribal criminal jurisdiction. And and the reason for that is because under VAWA 2013, it was mostly domestic violence related jurisdiction, and now under VAWA 2022, the tribe's jurisdiction is recognized in areas that go beyond domestic violence. So just wanted to make a note about that terminology. Similarly, VAWA 2022 introduces the term covered crimes, and the covered crimes is just a shorthand way to talk about all of those categories of conduct. There's a slide that'll hopefully make that a little more clear. And so VAWA 22, those changes, they change what can be charged in tribal court, and in some instances, who can be charged in tribal court. Everything that you could do under VAWA 2013, you can still do under VAWA 2022, but you can do more. So all of these changes expand what tribal justice systems can do in this area. Okay, so first talking a little bit more about what can be charged in tribal court. The VAWA 22 amendments to 25 U.S.C. 1304 added categories of conduct. Kelly and I have both mentioned that. Here's the full list. So you can see all of the categories of conduct that can now be prosecuted in tribal court. You can see the ones that were added in 2022 and the ones that existed since 2013. Again, this list, this is the complete list, is referred to as covered crimes. So when you see that term in the statute or when you hear it from Kelly and I, this is the list that we're talking about. Okay. The other change to what can be charged in tribal court that occurs in VAWA 2022 are some amendments to the definitions of domestic violence and dating violence. Again, those categories, tribal jurisdiction already covered those categories, but the definition of those terms in federal law has changed a little bit in order to give additional deference to how these terms may be defined in tribal law. Specifically, these changes remove violence committed language. For those of you that have been working with this statute, you know that definition had left tribes questioning whether or not they could prosecute domestic violence crimes that were not deemed sufficiently violent. I wanted to show you what that statutory change looks like. I think it's a little more clear. What you see in red is what's new after VAWA 2022 in this definition of domestic violence, and where you see the word violence struck out, that's what's deleted. So you can see that there's now a reference to the criminal law of the Indian tribe that has jurisdiction where the violation occurs. And so that what this is really saying is the term domestic violence means whatever your tribal code says it means, so long as it involves a current or former spouse or intimate partner of the victim, a person with whom the victim shares a child in common, a person who's cohabitating, that list in A, B, C, and D. So this is a really good example of how all of the definitions are structured in the new statute. Actually, I want to go back for just a second to my prior slide. All of these terms in the covered crimes, this list, these are all terms that are defined in the federal statute. So you can find a definition of domestic violence, dating violence, sex trafficking. All of these are defined terms. And throughout the statute, those terms are defined in a way like this one, where they refer back to tribal law. So there's really a remarkable deference to tribal codes, how tribes want to define these crimes throughout the federal definitions. Although, as you can see in this one, it's again a good example of this. There are some things that are kind of proscribed in the federal definition. So again, to talk specifically about this one, you can see that domestic violence is whatever the tribe says it is, so long as you keep the relationship consistent with A, B, C, and D in the federal statute. Okay, now I want to talk a little bit about changes from VAWA 22 that affect who can be charged in tribal court. So, I said a couple of slides ago that the victim usually needs to be Indian, right? So the VAWA 2013, the original framework, was trying to address cases where you had non-Indians committing crimes against Indians. That framework is largely still in place in VAWA 2022, except when you're talking about crimes of obstruction of justice or assaults against tribal justice personnel by a non-Indian. In those instances, the victim can be non-Indian. So for example, the classic example of this is you have a domestic violence offender. The tribal police respond to the scene. The responding officers, the responding tribal police officers happen to be non-Indian. The perpetrator, the offender, assaults one of the officers in the course of their effecting an arrest. That's a scenario that the tribe could now prosecute. So the tribe could prosecute the offender for the assault against their non-Indian officer. The VAWA 2022 amendments, as I said earlier, also removed the sufficient ties requirement. So that requirement that the non-Indian needed to be closely tied to the tribal community. And then the third big change is that it clarifies that tribes in Maine are able to implement this law. There had been some questions and uncertainty about that because of some specific things about the way the law is structured in Maine, and those are now have been addressed. Okay, so I'm going to shift now to talking a little bit about changes to due process protections that must be provided in tribal court under VAWA 2022. And there really wasn't much that changed. I'm going to talk about due process protections more generally in a couple of more slides, but really VAWA 2022, the main thing it does in this area is that it adds new language about habeas corpus relief. You can see the language. This is the statutory language on the screen. I know there's a lot of interest in this particular piece, so I wanted to share the statutory language with you. You can see now that when a defendant, a non-Indian defendant, is petitioning for a writ of habeas corpus in federal court, that's an avenue for them to get a federal court to kind of review what's happening in the tribal court. The statute now says if they want to do that, they have to exhaust their remedies in tribal court first. That was already the case, but it was the case because judges had said it was so rather than it being in the statute. So now it's codified in the statute. There's also new language. You can see at G here, notice habeas corpus petitions, that a participating tribe that's ordered the detention of any person has a duty to timely notify in writing such person of their rights and privileges under this section. That's a piece that we are still all kind of thinking about. What exactly does that look like? What's the scope of that? But what's important, I think, as tribes are thinking about implementing to know about this new piece is that that notice has to be made in writing. Okay, so now I want to step back a little bit. We've talked a lot about what VAWA 22, VAWA 2013 do cover, and I want to just kind of the flip side of that is what don't they cover? And again, they don't cover cases in general that are between non-Indians. So a non-Indian who commits sexual violence against a non-Indian, even if it happens in Indian country, even if it happens, at the tribal casino or someplace else clearly in the tribe's Indian country, the tribe does not have jurisdiction, again, except in cases of assault of tribal justice personnel and obstruction of justice. 1304 also does not cover crime that takes place outside of Indian country. And then an important thing that we always like to note when we're talking about this is this is all completely voluntary for the tribe. The tribe decides whether or not you want to implement this law and take on this responsibility, and whether or not the tribe takes on this responsibility, nothing about this alters existing state or federal jurisdiction. So if a crime occurs that the federal government has always had jurisdiction, they still do. It's just now there may be concurrent tribal jurisdiction. All right, now I said a couple of slides ago that I was going to talk about the due process requirements more generally, so I'm going to do that now. And basically, these are the due process requirements that apply under 25 USC 1304. It takes what was done in VAWA 2013 and VAWA 2022 and puts it all together. Okay, so We talk first, the tribal court, the statute makes clear that tribal courts need to ensure all applicable rights under the Indian Civil Rights Act. In addition, if there's a term of imprisonment that may be imposed, the tribe also has to provide all of the rights that attach under the Tribal Law and Order Act for enhanced sentencing. So you find those at 1302C. And then there's some additional rights that are required under VAWA 2013 and VAWA 2022. Here, this is the list of rights. They'll look very familiar. These are very similar to the constitutional rights that are afforded in US courts under the Bill of Rights. I'm not going to read all of these, but again, just kind of classic core constitutional due process rights. So in 2010, the Tribal Law and Order Act added some additional rights on top of those that were already included in the Indian Civil Rights Act for a long time. That included effective assistance of counsel, free appointed licensed attorneys for indigent defendants. There is a requirement that tribal judges need to have sufficient legal training and be licensed to practice in any jurisdiction in the United States. Tribal criminal laws, rules of evidence, procedures all need to be publicly available, and a record of proceedings needs to be made. Again, these are fairly typical due process rights that are protected in courts across the country. One thing I would note here, the requirements about tribal judges and sufficient legal training, they need to be barred. They can be barred by the tribe, and they need to meet a legal training requirement, but they don't necessarily have to have attended law school. And we're happy to talk more about that and provide resources if anyone has questions about that. Okay, so then talking about the additional due process requirements that got layered on top of those in VAWA cases. So in cases involving non-Indians, tribal court must provide the right to trial by an impartial jury. That needs to be drawn from sources that reflect a fair cross-section of the community and don't exclude non-Indians. So what that means, it doesn't mean that if every jury trial has to include non-Indians on the jury, but it does mean that the jury pool, the pool from which your jurors are drawn, needs to reflect a fair cross-section. So you need to have included non-Indians in your jury pool. And again, tribal court must ensure that defendants are timely notified in writing of their habeas rights. This is a chart that I'm not going to walk through. It basically is another way of showing all of those due process requirements that I just talked about on the prior slides. For some folks, especially tribes who have implemented enhanced sentencing authority under the Tribal Law and Order Act, it can be very helpful to see what you've already got in place because you were required to under TLOA, and then how you would layer VAWA rights on top of that. Okay. So there were some additional changes in VAWA 2022 that I think are worth talking about related to funding for tribal implementation. This is a question we often get when we're talking to tribes who are considering moving forward with implementing this law. What's it cost? What are the resources available? And since VAWA 2013, the Department of Justice has had a grant program that they put out that many tribes have made use of as they're planning to implement this authority and getting things up and running. Many of the tribes who had been exercising this jurisdiction under VAWA 2013 had shared, however, that grant program was useful, but that it wasn't fully meeting their needs, and that what they recommended, and which is now, Congress heard them and it's now part of the law, is that a reimbursement program be created that would allow tribes to recoup their actual costs associated with exercising jurisdiction over non-Indians. So we're not entirely sure right now what that program will look like. The Department of Justice will be consulting with tribes and promulgating rules for this new program, but it should allow for tribes who prosecute a non-Indian, for example, to be able to seek reimbursement for the cost of that non-Indian's detention or the cost of prosecuting that case. After VAWA 2022, the total amount of money available has also increased. Oh, I want to go back for a slide just to show you again. If you're curious about the funding that's available, there's a web address here at the bottom of this page, which is a good place to start. That'll take you to the DOJ page that talks about their tribal grant funding in this area, and should be where the information about the reimbursement program will be housed once that's up and running. Okay, the final thing that VAWA 2022 did that's worth, was very, very noteworthy and groundbreaking is it created a pilot project for tribes in Alaska. I'm not going to spend a ton of time talking about that. It's a topic that deserves its own webinar, and then there'll be a lot of work around this in the coming months. But basically, the goal of the pilot project, when VAWA 2013 was passed, because the unique legal status of land in Alaska, most of the tribes in Alaska could not make use of the authority under VAWA 2013. Only one tribe of the over 200 tribes in Alaska was able to make use of that authority. And this pilot project was designed to begin allowing tribes in Alaska to figure out a framework that would work for them to make use of this really important tool too. So it's called the Alaska Tribal Public Safety Empowerment Act. And what happens in this is that DOJ will be setting up a pilot project specifically for Alaska tribes, and they will also be able to then prosecute defendants for a covered crime. So same definitions, same scope of jurisdiction, and that'll be rolling out in the coming months.
Want to talk just a few minutes about the InterTribal Working Group, or the ITWIG. This is a group that assembled in 2013 at the very beginning of exercising special domestic violence criminal jurisdiction. This group is a brain trust in my mind. I've been with the group since 2013 and have just been so impressed by the extraordinary exchange of information. And it really does encourage peer-to-peer exchange of views, of information. Tribes share forms with one another. They share ideas and brainstorm with one another when challenges pop up. So it's free to join. We have meetings biannually. We have monthly calls for all members, for members by certain disciplines. So we would welcome you, if you are not already a member of the ITWIG, to consider that. Our next in-person meeting, we're hoping, we think might be the end of August, but it's not scheduled yet. So just letting you know, putting that on your horizon, that if you're interested, please join us at the ITWIG. Approximately 70 tribes that may have grown. And so I think there's a slide, just a couple of slides down, about who to reach out to if you're interested in joining the ITWIG. And this picture is from our very first meeting at the National Advocacy Center. And so you might recognize some folks in there. Next slide. Want to talk just a few minutes about technical assistance, the team, and I'll go into just a few more details of the types of technical assistance on a slide in just a minute. The technical assistance team consists of the National Congress of American Indians, the Tribal Law and Policy Institute, the Alliance of Tribal Coalitions to End Violence, and other partners and other experts as the ITWIG deems necessary to hear from. Next slide. And a few of the resources, including the TA tips, there it is right there. Free one-on-one technical assistance. And here are some of the types of technical assistance that TA team can come together to advise, assist, support tribes as they're making some of these adjustments. The TA team will review draft tribal codes, policies or procedures that tribes are thinking about utilizing to implement VAWA 2022. And I just want to say a word. It's more of it's a review that would point out potential litigation risk, leaving all policy decisions about how to move forward with the tribe. So very respectful of the tribe's authority and power to make those policy decisions. Help address specific questions about jury requirements. We've had a lot of requirements since 2013 about, well, how do we as a tribe go about identifying what a cross section of our community looks like to comply with VAWA. So we have experts we can tap to talk with tribes about that. We have resources on that. We can share how other tribes are doing that. Also, we help address questions about resources. Where do I get the resources? Do you have any resources available? We gather those up. And to help address any issues that come up with the investigation or prosecution of individual cases. Like I said, we have monthly calls. There's a call for prosecutors, a call for public defenders, a call for tribal judges, where tribes can get these questions answered, or we can at least do research and provide some support. Next slide. Couple of resources that we have focused on SDVCJ. We are busy preparing additional resources for VAWA 2022. You'll notice on the left 2 reports published by the National Congress of American Indians. The purple one you see is the very first report that came out as tribes were getting ready, getting geared up to exercise special domestic violence criminal jurisdiction under VAWA 2013. And then you'll see the 5-year report. What did tribes identify as challenges, as needs, as they're exercising VAWA 2013? And it's very interesting. If you read this 5-year report and look at VAWA 2022, you're going to see many of those challenges that were present in that in the exercise of VAWA 2013 being addressed by Congress. So also, let's see, there are a couple of resources on the side published by the Tribal Law and Policy Institute. There is a piece on TLOA. Virginia went through that. Those are the due process requirements required by VAWA, plus a couple of more. And then we have tribal domestic violence courts, tribal domestic violence dockets for courts that are for tribes that are interested in implementing those sorts of responses to domestic violence. Next slide. This is the contact information I promised with respect to, well, what do we do if we need technical assistance, or what if we want to join the ITWIG? And all you have to do is just to email that address, tribalvawa@tlpi.org, and just tell us what you need. We'll have people checking for that, and we'll give you further instruction. Next slide.
I think we're at the end of our presentation, Kelly.
Great. And do you have anything extra to add, Virginia?
No, just want to reiterate that we are the TA team. We love talking to folks as they try and figure this out, and providing what support we can to try and make it workable in tribal communities. So please do reach out at that email address if you have any questions, and we'll hope to see more people at the next ITWIG meeting.
Exactly. Thank you all for joining the Tribal Law and Policy Institute as we present this overview of VAWA 2022. Don't hesitate to reach out to us. Thank you.